All right, I do have 9 a.m. on my state issue computer, 9 a.m. on the dot, but we'll go ahead and get started. For the record, today is Thursday, October 27th, 2022. This hearing is being conducted both in person and telephonically using Microsoft Teams. Our commission member, quorum of the board, is present in person at the Volunteer Conference Center in Nashville, Tennessee. This meeting is also currently being recorded. If you have technical difficulties or for some reason get disconnected and are not able to rejoin the hearing, please contact Kawana Barbie. I'll give you her phone number as well. That direct line is 615-777-5386. We are present before the Tennessee Assessment Appeals Commission, who've been appointed by the State Board of Equalization to review initial decisions and orders of administrative judges and other related matters. My name is Robin Pope. I currently serve as Executive Secretary to the State Board of Equalization. I am designated to sit with the Assessment Appeals Commission as a hearing officer today. As the hearing officer, I will preside at this hearing. I will rule on questions of admissibility of evidence. I will advise the commission members as to the law of the case and otherwise ensure the proceedings are carried out in accordance with law. I will now make some introductions before explaining the procedure for today. During deliberations, Mr. Matthew Childress on my right will serve as counsel to the commission. He will assist the commission with questions during deliberations and offer guidance regarding the legal sufficiency of their conclusions. He does not, however, participate in any of the findings or otherwise make any decisions in these cases. I'll now ask our commission members to introduce themselves for the record, and we'll start with the man to my immediate left, Mr. Rhett Turner.
Rhett Turner, real estate appraiser, Mount Juliet, Tennessee.
And Mr. Brian Eads.
Brian Eads, real estate appraiser, Signal Mountain, Tennessee.
Mr. Osborne.
I'm Don Osborne, located in South Middle Tennessee.
And I just want to confirm while we do that, that everyone on our virtual call was able to hear our commission members. All right, I see a nod from Ms. Joins.
Yes, Keenan Given.
Thank you. All of the appeals today, that is our one appeal today, is to be conducted based upon the available record before the administrative law judge during the prior hearing. Pursuant to Tennessee Code Annotated Section 67-5-1506, quote, the Assessment Appeals Commission may affirm the decision of the hearing examiner or remand the case for further proceedings. The commission may reverse the decision if they find that the rights of the petitioner have been prejudiced because the administrative findings, inferences, conclusions, or decisions, that is the initial decision in order, was made in violation of constitutional or statutory provisions. That being, did the judge follow the law and apply it correctly? 2, was the decision made under unlawful procedure? Did the judge not follow some proper procedure, or is there some abuse of procedure? 3, was the decision arbitrary and capricious or characterized by abuse of discretion or clearly unwarranted exercise of discretion? That one's a little more self-explanatory. Essentially, was the decision arbitrary? Or finally, was the decision unsupported by evidence that is both substantial and material in light of the entire record? In determining the substantiality of the evidence, the commission shall take into account whatever in the record fairly detracts from its weight, but will not substitute their judgment for that of the hearing examiner as to the weight of evidence on questions of fact. Generally speaking, from legalese to normal parlance, that's going to mean, was there a basis in the record was there evidence in the record for the basis of the judge's decision? So was the judge's decision based on evidence in the record, including testimony available from the hearing? You cannot replace your judgment for that of the judge or the ALJ on questions of fact. So if the judge found certain facts you cannot find alternatively. However, you are able to see the entire record and note that there might be discrepancies in the record that would lead to 2 answers. You're not required to ignore parts of the record, but you can't replace findings of fact that the judge has made at the lower level. This means that no new or additional facts, testimony, documents, or other evidence may be presented to the commission. unless it is related to an irregularity in procedure that is not shown in the record. I will note that I have not received any notes that there was any claim of irregularity in these proceedings today. So essentially what that means is that if you are going to refer to any exhibits, it must be exhibits that were previously entered into the record. And you're not being sworn under oath. We're not receiving any testimony today. This is purely argument about why the judge's decision was correct or incorrect. A copy of the record has been previously presented to the commission members, shared via Microsoft Teams, along with any, except for Microsoft OneDrive, along with any written argument submitted by the parties in each case. I have a physical copy of the administrative record for each appeal with me today. I also have a physical copy of the initial decision and order for our appeal today. I will go ahead and hand out a physical copy of that initial decision and order for our commission members. We will proceed with our, well, we only have one case today, so it should be, we will proceed with you first. Let's go ahead and check microphones. Well, actually, we already did. I've already heard from Mr. Guyven and Ms. Joins, so we know those are working. These proceedings are informal. Board members are allowed to ask questions at any time. I will often specifically ask if the commission member does have any questions. Once we've heard all of the arguments to be heard today, I'll briefly describe the charge to the commission members before handing it over to the panel for deliberations. At that time, once the panel enters deliberations, there will be no more communication between the parties in the panel. I will also read a copy of the initial decision order of this case before we get into it, as well as recite the administrative record. With that, one piece of preliminary business I do need to ask is the commission identify a presiding member like we did yesterday. This presiding member will sign off on the final written order and otherwise preside over deliberations. I see nods. Is it? All right, we have Mr. Rhett Turner, who's volunteered to be our presiding member again today. With that, we'll go ahead and get started unless we have any questions from the commission on that. Okay. Our first and only appeal this morning is for in regards to Guyven Kenneth, property ID 057A C00900. This is for tax year 2021. This is a Wilson County appeal, appeal number 133435. Initial decision and order begins with statement of the case. The Wilson County Board of Equalization, hereinafter the local board, has valued the subject property for tax purposes as follows: a land value of $100,000, an improvement value of $489,000, for a total value of $589,000, and an assessment value of $147,250. The taxpayer filed an appeal with the State Board of Equalization, hereinafter State Board, on July 19th, 2021. The undersigned administrative judge conducted a telephonic hearing on this matter on March 9th, 2022. The appellants, Kenneth Guyven and Suzanne Guyven, represented themselves at the hearing, hereinafter the taxpayers. The Wilson County Assessor of Property was represented by Deputy Assessor Audrey Joins, hereinafter the Assessor's Office. Summary of evidence. The taxpayers testified on their own behalf, and Ms. Joins testified on behalf of the Assessor's Office. The following exhibits were introduced. Exhibit 1, the taxpayer summary of fact and email chain between the taxpayers and Assessor's Office. Exhibit 2, an additional email chain between the taxpayers and Assessor's Office that includes some of taxpayers' comparable sales. And Exhibit 3, the Assessor's Office's valuation analysis. Findings of fact and conclusions of law. The subject property in this appeal consists of a house built in 2014 at 311 Charleston Street in Lebanon, Tennessee. The taxpayers contended that the subject property should be valued at $525,000. The Assessor's Office requested that the local board's decision of $589,000 for the subject property's valuation should be modified and a valuation of $582,300 be adopted. The basis of the evaluation set out in Tennessee Code Annotated Section 67-5-601 subsection A is that, quote, the value of all property shall be ascertained from the evidence of its sound intrinsic and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As a property seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1-.11 subsection 1. At the hearing, the taxpayer, Kenneth Guyven, testified that based on his review of properties in the subdivision that nearby property owners had their assessment reduced, some by as much as $86,000, while his assessment increased. He further testified that rating of the subject property as above average is incorrect, and it should be rated as, quote, average, end quote, for assessment purposes. Mr. Guyven introduced comparable sales that he testified supported their contended value and stated that their comparable sales were more reliable than the assessor's office's comparable sales that contain wrong codes and inaccurate information that makes the sales not a good comparison to the subject property. Continuing on page 3, under cross-examination, Mr. Guyven testified that he did not hire a certified appraiser to value the subject property. The taxpayer, Susan Guyven, testified that the assessor's office's comparable sales were not similar to the subject property, and that comparable sales number 1 and number 2 contained incorrect square footage. Ms. Guyven further testified that the taxpayer's comparable sales were all near the subject property and supported their contended value. The assessor's office's witness, Audrey Joins, testified that their valuation analysis was based on the square footage according to the property tax card. Ms. Joins further testified that all her comparable sales were properly adjusted. Based on a review of the testimony evidence, the valuation analysis provided by the assessor's offices is compelling and appears to be a more accurate reflection of the value of the subject property. The taxpayers testified that the assessed value of their property had increased at a higher amount than other nearby properties. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of reappraisal. For example, the commission rejected such an argument in E.B. Kissel Jr., Shelby County Tax Years 1991-1992, reasoning in pertinent part as follows. The rate of increase in the assessment of the subject property since the last reappraisal, or even last year, may be alarming, but is not evidence that the value is wrong. It is conceivable that values may change dramatically for some properties, even over so short a time as a year. Further, the taxpayer's use of sale prices of nearby properties is not a reliable indicator of property values, as the values they rely on fail to make adjustments in values when compared to the subject property. Factors such as age, square footage, building materials, etc., were not taken into account in comparable sales listed in their comparable sales listed in their comparable sales. So these comparable sales are not a reliable indicator of what the home values are compared to the subject property. The Assessment Appeals Commission has said that for comparable sales to be relevant, they must be properly adjusted. In E.B. Kissel, Shelby County Tax Years 1991-1992, the commission said, the best evidence of the present value of a residential property is generally sales of properties comparable to the subject, comparable in features relevant to value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of comparability, it is difficult or impossible for us to use the sale as an indicator of value. Final decision in order at 2. The assessor countered with properly adjusted comparable sales contained in their valuation analysis. These sales establish a range in value for the subject property of $553,611 to $624,079. This led the assessor's office to recommend a value of $582,300 for the subject property, which is a reduction in value from the local board's decision. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. The assessor's office's comparable sales approach with proper adjustments with its modified value is hereby adopted. Order. It is therefore ordered that the following values be adopted for tax years 2021 and 2021. Land value, $100,000, an improvement value of $482,300 for a total value of $582,300 and an assessment value of $145,575. It then continues on page 4 with the appeal remedies available to the parties, including the appeal we are here today for. The order is then signed by Judge Jerome Cochran on March 30th, 2022. The final page being a certificate of service, noting that that order was sent to the parties. I will then also go over the administrative record we have before the commission today. On September 16th, 2022, a notice of hearing was sent to the parties. This notice of hearing included a updated list of a copy of an index of the administrative record. This administrative record was sent to the parties via Microsoft OneDrive, the same way it was sent to the commission members. The record consists of a record of appeal to the Assessment Appeals Commission. We've got a June 3rd acknowledgement letter sent by our office. We've got an April 25th taxpayer appeal supporting document. We've got an April 25th, 2022 taxpayer appeal, and as well as we've got an April 25th taxpayer appeal request email. As part of the record before the administrative law judge, we have a March 30th, 2022 initial decision order. We have a March 9th hearing recording of the hearing for Kenneth and Susan Guyven. We've got a March 9th hearing exhibit 1. We've got a March 9th hearing exhibit 2. We have a March 9th hearing exhibit 3. We have photos from March 8th that were pre-submitted by the taxpayer. We've got a March 7th taxpayers and assessors office's email chain. We've got a February 18th, 2022 appeal information and evidence. We have a January 26th notice of appeal before the administrative law judge. We've got a September 30th notice of status and scheduling conference. We've got an August 25th notice of status and scheduling conference. And we have finally the initial filing documents for June 22nd, 2021, the County Board of Equalization notice, or at least that's the date, I believe, on that. With that, that is the administrative record. Those are the only documents that we will refer to throughout these proceedings today. With all that said, I've read the initial decision in order. We've gone over those documents included as part of the administrative record. At this time, I will now ask our parties to briefly introduce yourself, just state your name, and then we'll begin with our taxpayer appellant and then allow the county to respond. And then we'll refer back briefly to our taxpayer for a brief response before we'll enter deliberations. Again, the commission, you're welcome to ask questions at any time. With that, I'll ask our parties to introduce ourselves. For the taxpayer, could you state your name and who will be speaking on your behalf? Mr. Guyven? Mr. Guyven, I see you are currently on mute. I'm not sure if we cannot currently.
My name is Ken Given, not Guyven.
Oh,
And
excuse me.
I'll be speaking on my behalf.
All right, and then for the assessor's office?
Hi, all. My name is Audrey Joins. I'm a deputy property assessor for Wilson County, and I'll be speaking on behalf of the property assessor's office.
Okay, thank you. With that, unless we have any preliminary questions from the commission. All right, seeing and hearing none, Mr. Given, I apologize for that mispronunciation. Go ahead and present your argument to the commission explaining why you think the administrative law judge's decision was incorrectly decided.
Okay, there were math errors on the evaluation he used of 582.3. The chart had math errors, columns didn't foot. The age adjustment on one of the comps was should have been subtracted, was added. They used $30 a square foot to build as the gross living area adjustment, where that Ms. Jones had used and talked about earlier. Using 113.86 is what she used in most of her comparisons. Obviously, that's still probably pretty low, but 30 is ridiculous. Another thing was that the square footage in some of the comps, comp 2, for example, the county has it at 3485. The actual square footage is 3925. How I know all this is because the same builder built my house, the one next door, and that one as well. And I looked at them, and you can go back to Real Tracks if you're an agent or whatever, and you can see what the real square footage is. And the situation there is, again, to prove this, my house listed for $495,900, and the one in this comp that we're talking about originally listed for $529,900. So that's pointing out some of the assumptions the judge used, which were in error. That basically, I guess, would be as far as pointing out that, that he relied on incorrect information. So that's my basis for appealing the judge's decision, is based on the errors that he relied on.
Okay, do we have any questions from our commission? Hearing and seeing none, we'll hand it over to Ms. Joins with the assessor's office to present their argument. Ms. Joins, I guess why do you believe the decision was correctly and or incorrectly decided?
Okay, the county is just requesting to affirm Judge Cochran's decision and order. I had presented 2 exhibits. In the first exhibit, on page number 1, that was my sales analysis. I feel as though that the comparable, the first comparable, the price is $625, which I adjusted to make $624,000. I feel like that was the most comparable property to the subject. I feel as though the judge looked at my comparables and made the correct decision. In Exhibit 2, I provided some supporting evidence on how the house was valuated, average or above average. In those documents, it just supports that this was a custom built home. It has stone masonry on the front. It's an all brick home. It is comparable. I don't know if y'all are aware to like Five Oaks, Horn Springs, other gated properties throughout the county. I did another evaluation on page 10 in the Exhibit 2. This was just.
Joines,
Oh, I'm sorry.
sorry, Mr. I was just going to mention we don't have all of exhibits. I can display them on the screen.
Oh, okay, that's fine. I'm sorry. I was just going in. I was just confirming. I would just like the decision order to be affirmed. I agree with what the judge decision was.
Thank you. I'll ask our commission members. Do you have any questions for the parties at this time? Mr. Osborne.
Not to interrupt, but I cannot hear.
Oh,
I
yes,
didn't
you might
hear
have to
that either.
really good in the microphone.
I didn't know if it's turned on or not. Thanks.
Yeah, I think you have to, because I can't hear the echo in the speakers either. I believe so. I can take mine over there though, if that works. Oh, now it's off. You gotta turn back on. A little green. You just might have to get. I don't believe she can. I'll just bring mine over there because I know this one works.
Yeah, I can hear that one.
Oh, no, you're good.
My question is, reviewing your residential sales comparison chart, looking at the 3 comps that you've got, comp 1 and comp 2 and comp 3 are all in the immediate neighborhood, it appears. Comp 1 has an adjusted sale price of $624.79, and comp 2 has an adjusted sale price of $553,611. Can you elaborate just a little bit as to why you feel that there's such a wide value range?
Sure.
Between those
Um,
sales?
The only explanation that I can give to you is the actual sale date. The sale date on the comparable two is 5/7/2020, and comp one was closest to our reappraisal date, which was January 1. That sale date was 12/9/2020. I try to get as close to January 1 as I possibly can. So we all know that the housing market is hot, and I think those two prices, the differences are an example of how the market was hotter between those months. Sales prices increased tremendously over that period of time.
Okay.
And furthermore, I'll just add to it, and I don't know if this matters or not. Now, new builds in that same subdivision are upwards of 900,000. So that it's just a trend. It's trending
Okay.
upward.
In analyzing your comparables that you used, did you consider doing a time adjustment for the sale?
No, because they were all within that first year. I generally don't if they're within that first year, because we can go all the way back to 2018. And if it was 2018 sales, I would have. I probably could have done a time adjustment, but I didn't. I chose not to. I'll let the prices speak for themselves.
So based upon the data provided, you believe your comp one is the most similar due to the fact that it required the least amount of adjustments, and it's right next door to the subject property in question.
Right next door, least amount of adjustments, and it is closer to our January 1 appraisal date.
Okay, very good.
Thank you. Any other questions from our commission members? All right, Mr. Guyven, if you have anything additional or response, you may go ahead and make that now.
Yes, sir. Yes, sir. Back to these sale comparison comps, et cetera. You pointed out that one of these was next door. There was another one next door that you don't have in your comps, which was 309 Charleston Street. That house I started to buy, it was more square footage than mine, just 150, but it's a 4-bedroom rather than a 3. It also had a formal living room, and it sold on 3/4/20 for $525,000. I pointed out many times to Ms. Jones that the house that she's referring to is next door, the best comp at 313. That is an outlier if I've ever seen one. These people wanted the house because of the view. The house in no way was worth that kind of money. Nobody would have paid it. Okay. If you go back and you look at all right, for example, she had 3 different in all of that information there, the 160 plus pages of data that's in my administrative record, some photographs, spreadsheets, narrative, comp comparisons, but she never did have any comp comparison that every one of them that she did always used that outlier. Okay. If you took, for example, let me read you this. Had 4 properties in 3 comparison charts. 303 Charleston.
Mr. Guyven, I apologize. I hate to interrupt. I just could you identify what page or what documents you're referring to? You're reading from.
Well,
I'll highlight it for the commission members.
It'd be on one of these 3 comparison charts. Exhibit B, which was the 582.3. Exhibit D, which is our 586.8, and then
Okay, just to reaffirm. So I read a copy of that notice of the administrative record. I need a kind of an exhibit name. It's one of the documents that we shared via OneDrive before this hearing. We have, so the initial decision order notice 3 exhibits, the taxpayer
I know.
summary of fact and email chain, or the,
Well, every bit of the information I'm quoting you is found in that administrative record, okay? All I'm trying to tell
yeah, I
you.
just, yes, I just before, well, I need to make sure that what you're presenting is part of the administrative record. So I'm just asking you identify where it is. And that
Well-
way I can also help facilitate and highlight that and display it for the commission members.
I sent you an appeal of the judge's decision on 4/25/22, okay? Is that in the administrative record?
Hold just one moment. Let's see.
It was 2 pages of narrative and exhibits A through G.
All right, I have your narrative here, and then I have
I
exhibit
just saw it
A.
go by on the screen, okay? Just saw it go by. There's exhibit A where she had first offered me one time to settle for $565,000. And then if you keep going, the things that I'm referring to right here, let me just say this, I'm referring to exhibit B. You see that one? And keep going on down. I'm going to refer to exhibit D and exhibit E, okay? Then finally, I'm going to stop right now. Let me just say this, that in those exhibits, for her properties, she used the 313 Charleston on every one of these comparisons, okay? But then she used 4 other properties, 303 Charleston, which is down the street, used once. 303 Charleston, which is right next door to me as well, used once. 220 Moorhaven, she used twice. And 158 Hamilton Springs Boulevard used twice. Well, what I did was, if you will scroll on down to exhibit G, which is, keep going. All right, there we go. If you took and you corrected the mistakes that I had already corrected in these things, square footage and so forth, which I proved, and if you read the narratives in every one of these things, for example, and that's 4 comparisons right there. That's 4 properties, like sales. Okay, let me get to my chart here. The comp 1 was 309 Charleston, comp 2, 303 Charleston, comp 3, 220 Moorhaven, and comp 4, 158 Hamilton Springs. If you take all of those properties and you average after the adjustments based on the square footage using 114 or 113.86 a square foot that she used in most of her stuff, not the $30, which the judge relied on, and you do all the adjustments that necessary, you come up, if you average those 4 properties, once they're adjusted, sales prices adjusted down, up or down, the average is $527,445, and I'm asking for $525. Okay, let me just read you in case you guys can't see the narrative at the bottom of this exhibit G. Comp 1, 309 Charleston is next door, was built by the same builder as my house. It's 150 more square feet, has 4 bedrooms. Mine only has 3, also has a formal living room. Original list price was $499.9. My house was $495.9. I originally sold the 309 Charleston originally sold for $489.9. I paid $466,105. Okay, I'll give you the HUD statement if y'all need it. All right. This information, square footage, I sent to Judge Cochran after the hearing, and it's Eastland Construction. They build houses everywhere. And obviously they're not going to be, if you can look at real tracks, whatever you want to do, but basically this house is a bigger house and it was a 4-bedroom house, nicer house. Not to mention that a lot of things have been done since. 303 Charleston, the house down the street, was built with the same builder. 578 more square feet, has 4 bedrooms, my house 3. Original list price $529,900. My house was $495,900. Originally sold for $519,900. I paid again $466,105. Now, if you average these 4 houses, like I said, the comparative sales price is $527,445. And if you wanted to add in the outlier, which I'm telling you is a true outlier, and these people had more money than they got brains, but they paid $625, and if you average that one in and and divide by 5, the thing comes to $545,861 average. So just for the record, this is the real comparative stuff. Now, another thing I'd like to point out, while I guess this is my last time to speak, was the situation that started this whole thing. The reason I questioned this was I had a neighbor across the street, Mr. Reynolds, who told me back in the very beginning, 2 years ago, that he called up there and talked to some lady, and he told her that various things, if windows leaked, whatever, she changed his codes and wrote him down some 80-something thousand dollars. And I said, well, your house sure makes mine look sick. Swimming pool, all kinds. I mean, and you can look at that in some of the pictures that are in one of those exhibits of 30 some odd photographs. Yeah. But so that started me to thinking about, well, how's everybody being treated here? So there's 30, at the time there was 30 something houses in this subdivision. And so I luckily, I knew what everybody's original assessment was. Now, what happened if these people called up the county and the county cut them down $80,000, the state website was, the history was gone of what it originally was. But luckily, our office up here of the, I don't remember what you call it, but anyway, they had a website, or had a list of every property's original appraisal. So I was able to make sure that I checked I could get everybody's original numbers, not adjusted. Well, what I found was in these 30 something houses, that there was like 6 or 10, 10 total, I think, that had some kind of adjustment. It came on down to where really the 4 largest, other than the man across the street who had a code change, all, I'm gonna name them. There was one that was 65.9, one that was 104.3. There's another named Wilson, 119.1, and another one for 85,000. So I asked Ms. Jones during this hearing with the judge, and many times before, how did these people get, or what was the basis of their write down in value? And she says they were fee-based appraisals. Okay, I said, well, who did the appraisals? Well, never got an answer. I asked for copies, never got an answer. One of these people I knew who was an executive with Wilson Bank and Trust, Mrs. Dernberger, got 85,000 off, and I talked to her. She was a branch manager, and she told me that this thing, it was based on a home equity loan document that the Wilson Bank put there as a free of charge. And I called the president of the bank. Of course, I worked for
Mr. Given, I apologize for interrupting. I just want to refocus. So again, we were focused on your arguments as to why I understand you have concerns about other assessments. Mr. Given, let's let me interrupting. I apologize, but we're focused. I know you have concerns about other assessments in the neighborhood. Our hearing today is limited to why you believe the decision of the administrative law judge, that decision I read at the beginning of this hearing, was decided correctly or incorrectly. And so, although I know you have other concerns,
that is part of it, my friend. I pointed this out to the judge during the hearing, So that's what I'm speaking to, is why I feel that his decision was based incorrectly. When I pointed out to them that the Sternberger house, was based on a home equity loan, not a real appraisal. And I talked to the president of Wilson Bank, and the Wilson Bank president said, there ain't no way, this is not a certified appraiser. This is, about 50% of what the value really is, maybe less. So if you took this is another non-sales, but if you took that Sternberger house, which also was built by the same group at the same time, and she got hers marked at $535,000. It is basically the same square footage as mine, plus the lot. My house, using her square foot, my house would be 515,329. So there is another figure that actually shows a value that is considerably lower than even what I asked for. Now, basically, this is all I have to say, and you guys can do whatever you want to do, and I know you will, but I'm CPA retired. I had a real estate license with A.G. & Johnson. I know something about the value of property. So I think that's about all I have to say. So appreciate your time.
All right, thank you. Do we have any questions from our commission members this morning? All right, hearing and seeing none, I'm going to walk back over. So Mr. Osborne, you have a working microphone. We'll enter deliberations. Just a reminder as we enter deliberations, there'll be no more communication between the commission member and the parties. Mr. Turner is our presiding member. Any member can make a motion. Generally speaking, your charge is to decide, did the administrative law judge misapply the law cited in this case? Did the administrative judge otherwise act outside of the scope of his authority? And was the decision supported by substantial and material evidence? Your options today are generally to either A, affirm the decision of the administrative law judge as is. B, you can remand it back to the administrative law judge if you find that the order is deficient or does not adequately address certain issues that need to be addressed in order to make a valid decision. Or C, you can reverse the decision and we have specific instructions on what needs to be fixed or changed in that decision, and we'll go back to the administrative law judge to adopt those changes. So again, that's basically three options: affirm, remand for further proceedings. That is, if you think that the order as written needs to have some other additional finding or is missing some essential facts to support that decision. Or option three, reverse some decision made in that order with instructions to the judge of what to fix. So with that, I will hand it over. Any commission member may make a motion, and then we can do a voice vote on that. Now, let me see if I can maybe. Oh, I broke it. Hello? I think it's working. Yeah. Just touch it. All right, I think we got that working. Do you want to give us a shout, Mr. Osborne? Make sure we can.
Okay. Hear me?
It's going in and out. Here, I'll just give you.
Testing,
Yeah.
testing,
Oh,
testing.
there we go. Okay.
We'll get it.
Thank you all.
Does anyone have any questions or comments or further discussion, gentlemen?
I don't at this time, no.
I do not.
Hearing no further discussion or question or comment, do I have a motion to affirm the assessment as stated by the judge? Did I word that properly?
So are you making a motion to affirm the
Yes,
decision?
I'm asking
Okay.
if anyone would like to make a motion to move forward. Yes.
I make a motion that we affirm the ALJ decision.
All right, so we've got a motion to affirm the decision by Mr. Osborne. We've got a proper second from Mr. Eads. Any more deliberation or discussion on that motion? Seeing and hearing none, all in favor, say aye.
Aye.
All opposed? Let it show that the ayes have it with all three members voting aye. With that, that concludes our business for today. We will send out a written copy of this decision within the next 90 days. That decision will also explain any further appeal rights. This concludes the business for the Assessment Appeals Commission this morning. So with that, I will go ahead and end the recording and end the meeting. Thank you all for attending. Thank you all.
Thank you.
See you in Chancery Court. Good day.